very, very welcome along this morning. This is our first face-to-face event in over 2 years, and it's great to be back in a live setting. When I realised there was a CPD event on this morning, my first instinct was to reach for a pair of tracksuit bottoms and a Joy Division t-shirt, but that's not really going to cut it for a day like this. Can I say a special word of welcome to my colleagues at IT Sligo, Valerie McTaggart, the head of business, and Ruth and Esther from the law faculty. We are now at T-minus 7 days, I think, from launch. IT Sligo will be dissolved on the 1st of April, and the newly constituted Atlantic Technological University will take its place. And I think that's going to be a very proud day for Sligo, and I think it'll be particularly good for the region. So I just wanted to acknowledge that. This is our hopefully first CPD event of many. Over the last few years, Chartered Accountants Northwest seems to have captured the zeitgeist. We did a huge amount of work on Brexit preparedness, given that we have many of our members operate along the border region. And during COVID in particular, we did an awful lot of work around wellness, sustainability, the use of technology, and adapting to the new paradigm that COVID brought with it. And I think today's topic also is going to resonate very much with you this morning. Just in terms of our speaker, unfortunately Alastair can't be with us today. He had to attend a funeral at very short notice, but we're delighted to welcome his colleague Robin along this morning to give you an update on employment law. Robert has huge experience as an advocate at the Workplace Relations Commission and at the Labour Court, and he has extensive experience ranging from unfair dismissals all the way through to the various forms of dispute resolution. He does an awful lot of work in relation to bullying and harassment, protected disclosures, and probably the four most dreaded were letters in the English language when combined: GDPR. And he may touch on that particular issue with us this morning. Just in terms of housekeeping, we do have, you don't have to wear a mask. If you want to wear a mask, you can. We have sanitizer on the tables. We're delighted to take any questions that you have at the end of the presentation. And also just to mention that this morning's presentation is being recorded and will be available subsequently, so you can look out for that as well. So with no further ado, can I introduce our speaker this morning, Robin.
Thanks for that, Michael, and particularly that clarification regarding Alastair. I know probably a lot of people walked in and said, Jesus, COVID's done wonders for Alastair in terms of youth and height. So in terms of what we're going to talk about today, and probably I should start by saying Alastair has apologised for not being here. He would have loved to have been here, particularly given it's a face-to-face. It's very refreshing having been in front of a screen for 2 years. But look, he sent me in his place, and hopefully he can come out of here with just a slight bit more knowledge than he did coming in. So as Michael touched on, we're going to talk about employment law, okay? And before we kind of get into the meat and potatoes of what we're going to talk about, I just want to kind of set a context very briefly about employment law. And Michael touched on it in respect to COVID. I think I can safely say that everyone in this room in the last 2 years has invariably, either directly or indirectly, become more conscious and more aware of employment rights and obligations. I think for some reason something has happened that has caused a spike in that. And I think the obvious answer is COVID-19. And in essence, what it has done, it has shined a spotlight on it. And if you think about it logically, overnight in March 2020, everything that we were used to changed. And that is no joke. You know, the systems of how we worked, the procedures and so on. We went from a four-cornered office shared space with a multitude of people with paper-based systems on a workstation that was provided to us, to then suddenly being in isolation, working on our own, working from our own laptop, and that was it, working for our own time. So if you think about that, that's a sudden shock for everyone, and particularly for employers, and that was a huge anxiety shock, because from an employer's point of view, we had a controlled environment. We could oversee, we could monitor everything, to then going to a place where we had no oversight. It was unregulated. We had no control. So the sharp reaction in return was that employers needed to overregulate. So they started looking into compliance issues. They started looking into well, how can we ensure compliance so liability doesn't fall back on us? So they started looking at health and safety. How do we make a bedroom a safe place of work? We started looking at GDPR. How do we prevent someone from printing a document and then putting it into the recycling when it contains commercial information and personal data? Because that, in essence, is a data breach. So how do you prevent that? How do you manage it? Then we go on to working time. How do we regulate working time when someone cracks open their phone at 8 o'clock in the evening and sends an email when really they should have finished at 5:30, when it's easier in the office to just tell them to go home? Now, in reality, that really never happened. But that was the issues that was faced by employers. And for the first time as employees, we had to try and navigate a paperless system and try to understand what a cloud-based system was. And that was very much difficult. And there was a huge learning curve. But as a positive from COVID-19, we've seen a sharp reaction in terms of progress and development, particularly in legislation. We see that now with the statutory sick leave. We see that with the remote working bill and the right to disconnect and so on. And that would have never happened but for COVID, because it accelerated it. And if I just go back to that idea of a spotlight, what that spotlight did was it unveiled that kind of minefield that employers need to navigate and for employees to understand. So look, hopefully I'm just going to touch on those issues. We're going to talk about legislation developments that you're probably sick to death hearing about. But I'm hopefully trying to give you a different kind of take on it, a different insight. We're going to look at then trends that we're seeing from an employer's point of view in terms of the types of cases that are being taken in the WRC, the types of cases that are winning, and then we're going to focus on specific case law examples that are causing routine problems for employers. So if we just go on, they're the topics that we're going to talk about, but I'm just going to launch straight into the legislation, and I'm going to fly through this fairly quickly because it's very monotonous stuff. For Family Leave and Miscellaneous Provisions Act in 2021, that came into force, and for those who don't know, parents' leave is now a thing. You now used to have 2 weeks. It's now been increased to 5 weeks by virtue of this act. And originally you had to take those 2 weeks within 1 year. That now has been extended to 2 years. So you have 2 years now to take 5 weeks, and that's per parent. Now, what this represents, it represents an increased trend of increased protective leave. You know, previous to this, we saw the parental leave go from 18 weeks to 22 weeks to 26 weeks. Before that, we saw the introduction of paternity leave. And this is only set to increase. They're already thinking about increasing it to 7 weeks. And if you look at the amount of protective leave currently on the market, and you take a sample employee, okay, it's primarily a female employee. If you were to take that individual, in theory, that person could take up to 3 years and 5 months protective leave between parental, maternity, parents, carers leave, and so on. That is 3 years, 5 months of protective leave. And that's leave which their employer cannot dismiss them, they cannot change their job, and in theory, cannot change the structure around their job. So this is only going to set to get more and more prominent, particularly with paternity leave being touted to go to 6 months, the equivalent to maternity. So moving on to retirement ages and pensions. Now, I find this incredibly interesting stuff because if you look at the data around 2018, for some reason, there was a huge spike in retirement and age discrimination cases. We went from 200 odd cases a year suddenly to 700. And the question at the time we had to ask ourselves, well, why was that? Well, it was primarily due to the fact that the state pension age went for the first time from 65 to 66. So now we had this disparity between contracts in Ireland, which were primarily focused on the retirement age of 65, to then being left without a pension for 1 year. So what did people want to do? They wanted to continue working. And this was then kind of supplemented by the introduction of the longer working code of practice, which set out a kind of a procedure for employers managing employees and them working longer. And employees wanted to stay, and employers didn't want them to stay. And that created a huge spike in cases as a result, with people then often winning because the success rate in those cases were abnormally high, and the awards often reflected the shortfall between the retirement age of 65 to the pension age of 66, so a year's salary. So what happened in response to this, the state pension age that was due to rise to 67, the government were like, we can't do this. This clearly is problematic. So what they did was they established a commission for pensions to review the state of retirement within the workplace. And then this commission identified a number of key issues in October of last year. And those were that employers shouldn't be able to force people to retire before the state pension age, so as to try and align that. And they said that legislation should be introduced to make the retirement age within people's contract to be akin to that of the state pension age. Again, trying to bridge that gap and trying to stop a disparity and allow people to increase their payment by voluntarily deferring their pension age to 77. That would allow them to increase their PRSI contributions and so on, which makes sense, and then to freeze the state pension age to 66. Now, the only thing as a solicitor I can always say with these things is that if you don't have a retirement policy, you should have one. And then you should be asking yourself, is my retirement policy compliant with the code of practice and the procedures set down in that? Because although it's not law, it is binding. And if it's binding, it can be relied upon. And if you're not complying with it, it's a breach then of the code of practice and a liability arises. Now, since then, because people have started to become more compliant, we've seen a drop in the cases. So we've seen that spike, and it's now dropped to around 350 cases per year at the moment. So let's kind of move on to one of the main pieces that we're going to talk about, which is the right to request remote working. And again, I'm sure you've seen all of this. But my view on this is that this is an incredibly flawed piece of legislation. It's not what we wanted, it is not what we needed, and it is completely one-sided. And I'll come back to that at the very end. But what is the right to request remote working? Well, that's what it is. It was published in January last year, 1 year after it was originally touted and 6 months behind schedule. It requires employers, and this is every employer, not based on size of the organisation or your type of organisation, it requires every organisation to have a remote working policy. And if you do not have that policy, it is a criminal sanction, and a fine of up to $2,500 can be imposed, and which is quite strong. Now, employees who have completed 6 months or 26 weeks service will be eligible to apply for remote working conditions, which is sensible, and that the remote working assessments and outcomes will need to be communicated within 12 weeks. So as soon as I make a request to remote work, the clock starts, my employer has 12 weeks to resolve that. And if they don't, that is an action against them. Now, what does a request look like? Uniquely, the bill in its current format says the employee makes the request. That's normal. But what they do is that they will propose the remote working location. So it does not necessarily have to mean their bedroom. It can mean Dingalingerry. It can mean absolutely anywhere. They must propose the start date of when they would like to start a remote working arrangement, the proposed number of days per week they wish to work, whether it be 2, 3, or 5, as well as that if an individual has made a previous request for remote work, they must identify if they've done so, because we're only going to be allowed to make one request every 12 months. Now, interestingly, if I get a lateral promotion, I'm allowed to make a fresh request in light of that new position, regardless of the 12-month rule. Now, this last box down here is quite critical, and this is what I don't understand, is it is up to the employee to self-assess their remote working station. So that means they have to assess whether their workplace is GDPR compliant, whether they can ensure confidentiality, that there is a minimum level of internet connection. They have to seemingly assess the ergonomic suitability of the proposed workstation, which does not make sense. If you asked me to ergonomically assess my chair, I couldn't tell you. And more to the point, if you look at the GDPR regulations, the onus is very much on the employer and not on the data subject to assess the security of their systems. But according to the remote working legislation, it is up to the employee to propose that. And that is incredibly flawed. And if you actually read the general scheme, which is the guideline behind the bill, it in no way suggests that the employer can go into the remote working station or someone's bedroom to assess the viability of it. It's very much up to the employee's discretion. Now, in saying that, the employer may request further details. Now, actually, just to go back to the internet connectivity thing, and I've seen this recently, I would suggest that if your internet connectivity is anywhere below 35 megabytes download and 25 megabytes upload, and what that means is the amount of information I can download and the amount of information I can send out. If it's anywhere below that, in theory, they say you lose up to 20 to 25% productivity on a daily basis if you're working off a cloud-based system. So just to bear that in mind, and that's why you would need a strong internet connection, and that's why remote working in certain remote locations will not be generally suitable. Now, an employer must respond within 12 weeks from the request, as stated, and confirmation if someone is acceding to the request, they must provide details of the arrangement, the proposed start date, whether it's going to be a trial period. And look, in our experience, we are seeing that remote working arrangements underpinning contracts are being entered into. So it's akin to a contract of employment. So it sets out how an employer governs that, and it's really working strongly. and rather than having no arrangement in place at all. Because if you have a fallback clause within that arrangement that allows you to effectively, if they fail a probation period on the remote working, that you can withdraw it, and it does work quite well and is recommended. If the proposal does not meet the requirements for the employer, a counter proposal can be made under the legislation. The employee has 1 month to accept that. If they are dissatisfied, they can appeal it. Now, it's not an internal appeal within the organisation, it is an external appeal to the WRC. And if appealed to the WRC and successful, if they prove that 1, it was not responded to within 12 weeks, if the response was inadequate or flawed, they can get up to 4 weeks compensation. So in terms of the reasons why, there are 13 reasons why you can refuse. These are the most prominent, which I believe to be the most relevant for most employers. We see that the nature of the work, for allowing the work to be done remotely, is not suitable, that the work cannot readjust work amongst existing staff, that it will have a potential negative impact on the employee's work itself and their performance, additional costs, which is a huge aspect because the average remote working station at the moment is in around €2,500 to €3,000. It's not cheap. It really isn't. So as well as that, if you cannot guarantee intellectual property, confidentiality, data protection, which I can really make the assurance here now that no one can guarantee data protection at home. They just can't. It's virtually impossible in this day and age. And that, or there's an inordinate distance between the remote location and the place of work, which is an interesting one. Now, what's great is if you look at that general scheme that explains the refusal process, the way they describe it is that the employer must give due consideration. So you cannot simply decide on the spot. You need to take a few days. You need to propose it amongst a management meeting and seem to be taking minutes of that meeting so it's discussed. And then you need to be able to rely on a business need as to why you're refusing it. It cannot be an arbitrary reason like, we don't like that person, they're a bad performer, and so on. But interestingly, the way they describe the decision making is that it is entirely subjective from the employer. So the employer, according to the general scheme, retains absolute discretion, no matter what. So in other words, if the employer doesn't want it, it's not happening, and that's it. The code of practice and the right to disconnect. Kind of keeping in with the trend of flawed legislation, this is certainly, in my view, arguably the most pointless legislation that has come into effect in Ireland, because it achieves absolutely nothing. The idea of the right to disconnect is to separate us from the workplace and to stop us working additional hours. Has it achieved that? No, it hasn't, because it's a code of practice. And for those who don't know what a code of practice is, it's not legislation. It's a guideline that underpins the legislation itself. So in theory, it's not binding. But again, to what I said earlier, if you don't comply with it, it can be relied upon in evidence in a hearing. And therefore, you need to be seen to be complying with it almost. So this came into effect in April in 2021 and has 3 main components. One is that we're not expected as employees to routinely perform work outside our normal working hours. Now already, I'm here at whatever time it is. I started at 7 o'clock, I'm at my employer's disposal. I'm performing work outside of my normal working hours. So it cannot be guaranteed. You also cannot be penalised for refusing to attend to work matters outside of normal working hours. I wasn't going to say to Alastair there yesterday that, sorry Alastair, I'm not going to this event, but the reality is that I have to. And that the duty to respect another's person's right to disconnect. So I shouldn't be sending emails outside my normal working hours, but I didn't get down here till 7 o'clock, but I had to send about 20 emails last night to different people. So it just doesn't work because it's not binding. In France, we have systems where no matter what, you can't access your emails after 5:30, which works, I imagine. But this is simply just recommending that we do this. Now, what's really interesting from a technical point of view, for those who are familiar with working time, the employer needs to record our working hours. They need to record our rest breaks and so on. That is a strict liability. The employer needs to be seen to be complying with this. In accordance with the code of practice, it uniquely shifts the onus to managing working time to the employee. So what the code of practice suggests is that if there's a system in place, the employee should be adhering to it. And that's actually incompatible with the Organisation Working Time Act. So it's not only is it not working, in theory, it is flawed. So it's questionable in that regard. But it is helpful if you're an employer. The code of practice does recommend that a right to disconnect policy is implemented, and this is a good opportunity for an employer to list scenarios of when an employee can be expected to perform work outside of their normal working hours, because it does facilitate that there will be legitimate reasons as to why I'm required to be here and so on and required to travel. So the sick leave bill. Now, this is probably 2022's greatest misconception. in that people think that this is currently active. For some reason, this is a weekly call that I have being like, do we have to pay sick leave? I believe this legislation is implemented, and the answer is no, it's not. It was meant to be, but unfortunately it's not at this moment in time. And this was originally published in November 2022, and it proposes that we as employees get 3 days statutory sick pay off our employer, and this is due to increase to 5, 7, and 10 days by 2025 gradually. And employees will generally be entitled up to 70% of their daily rate. So that's your daily basic remuneration rate, not your pension contributions, not your bonus, not any other entitlements, your basic daily rate, subject to a cap of €110. And I kind of worked that out. If you're earning more than 28,000 a year, you're losing money based on the statutory sick pay per day. You must have 13 weeks service. Absent must be certified by a medical practitioner with their name. And any leave during a statutory sick leave will be deemed protective leave. So we're adding to that protective leave that we originally talked about. If I am absent on statutory sick leave during probation, that probation period is suspended, but it's only for 3 days, so probably will have no material effect. From a GDPR point of view, statutory sick leave records must be kept for 4 years from the date at which that individual was absent. And if I don't get to avail of my right to statutory sick leave, again, I can go to the WRC and get up to 20 weeks compensation. So again, this is not in place. They're saying June. I do not see it coming in until the end of the year because it hasn't gone through the first stage of the Oireachtas as far as I'm concerned. So moving on to the Protected Disclosures Amendment Bill. Now, protected disclosures is a big kind of issue for me. I'm a big fan. It's interesting stuff. And this new directive is going to overhaul the current legislation for protected disclosures. And the deadline for implementation, and it's very much in keeping with everything we're talking about here, has passed and it hasn't been implemented yet. So we're actually breaching EU law, if you want to say, as a nation. And what this amendment is going to do, it's going to revise reporting channels for every organisation over 50 people by 2023. And what this means is that if you have a whistleblowing policy, this now needs to be revised to reflect the reporting deadlines, the reporting obligations, and so on. So now when someone makes a protected disclosure, we now have to acknowledge receipt of that disclosure within 7 days. We must then follow up by an impartial investigator within 3 months to give them an update or a progress review as to what's happening with their protected disclosure. We then must provide feedback or actions taken within 6 months of that disclosure being made. And at all times throughout that, they're saying that confidentiality must be maintained. But how do you maintain confidentiality? And what they've recommended is that we outsource protected disclosures, presuming, should I say, that you're a sizable organisation that can afford this. And what a lot of organisations that we deal with, they have outsourced it with kind of hotline scenarios where phone this number if you have a protected disclosure, communicate that, and they will manage it, and they will appoint an investigator to deal with it, which is in no way feasible for smaller organisations, so on. But it really is going to overhaul any whistleblowing policy that someone may have. Now, the definition of worker has now been expanded. Traditionally, only an employee could make a protected disclosure. Now, a shareholder, non-executive directive, a trainee, a volunteer, as well as someone who's applying for a job can now make a protected disclosure. Now, interestingly, with the last one, they can only make a protected disclosure about the recruitment process and nothing else. Okay? And that's tenfold the definition. They've really expanded upon it. And critical, and what is absolutely necessary, is that interpersonal grievances are due to be excluded. Because, again, on a week-to-week basis, we get a scenario of an employer ringing us saying, Paul in accounts has made a protected disclosure that he doesn't like Jim in management. And he says it's a protected disclosure. And in theory, we can't say otherwise. We can't say to Paul, go down the grievance route, because the Protected Disclosures Act doesn't allow for that distinction between grievance and protected disclosure. It only states a wrongdoing, and a wrongdoing has to fall within a certain definition. And we'll come to a very interesting case that was heard in the Supreme Court on this just a few weeks ago. And it's now distinguishing between the two, which is going to help workplaces significantly on this. The definition of penalisation will due to be expanded. Now, traditionally, penalisation was were you fired for having made a protected disclosure. This is now going to include negative performance reviews, withholding of training, and medical referrals. Interim relief, which is injunctions, can now be applied for as well if I get a negative review. So other forms of penalisation. So if I'm not happy with the performance review and I've lodged a protected disclosure before that, I can now march into the circuit court and get an injunction on that. And it's phenomenal, really, because that injunction was always reserved for situations where you were dismissed. But if you feel like your reputation is on the line, then you can get that injunction, and the cost of that would be anywhere between 60 and 70,000 for the organisation. It's just kind of crazy when you kind of sum it up. Compensation will then be available for the WRC for people who don't receive salaries, okay, so have not received remuneration yet. So you talk about the people who've made protected disclosures about the recruitment process, who haven't commenced yet. Because they haven't received a salary, they will be capped at compensation of up to 15,000 when traditionally it was 5 years' pay. So the gender reporting pay gap, now this has kind of been going on for about 5-6 years, and it's finally come into play since last year. And this will examine the differences between pay between men, women, as well as their bonuses. And critically, organisations will now need to provide reasoning as to why there is differences. So if there's a difference between part-time female workers and part-time male workers, the employer needs to explain why. And they need to identify steps to what they're taking to mend that gap where possible. Now, just last week or the week before, the timing for the reporting of the gender pay gap is set to take place in June and in December. So we're effectively going to take that snapshot in June and see what the effects are in December and whether any changes are made. So those reports will have to be made. Currently, our gender pay gap is at 14.4, which is kind of higher than the EU average. Data will have to be published. The manner of publication, though, is currently unknown. Most organisations like PwC, kind of those higher standard organisations, they are publishing on their website. It is kind of touted at the moment that there's going to be a general one-stop shop for this information, but that hasn't been created yet. And any non-compliance for reporting gender pay gap, no compensation is available. However, you can get an order from the court to say that this organisation has not done it and it needs to be done. So just going on to case law. So that was our statutory stuff, and I'm kind of glad to get over that because it's very much monotonous and you're very much familiar with it. But now I just want to look at trends because it's critical looking at trends really, because we have this new system that allows us to look at this data in great detail. And just kind of looking at the WRC, we only have the data from 2020, and I think 2021 is going to be a far more telling year for what trends really look like. But if we look at 2020, kind of as an overview, there was 8,000 complaint forms lodged. Overall, there was 19,000 specific complaints. So don't forget, on each complaint form, there could be multiple complaints. There was 7,700 inspections. There was over 1,700,000 in recovered wages for employees. And there was 40 compliance notices served. And that means if an inspection is carried out and they realise that certain organisations are non-compliant with working time, that is a compliance notice. And that there was total prosecutions, which are criminal sanctions for non-compliance. Now, if you look at the 2019 and 2020 trends of cases, in 2019, there was a higher amount of individual complaints, and you look at also a higher amount of specific complaint forms. So this represented a 2.5 decrease in applications in 2020. So for some reason, there was a drop in cases, which is unusual because you would assume that in 2020, cases were on the spike. And actually, in our experience, that 2020 was quite a low year. And 2021 wasn't exactly the spike that we predicted either. We thought that redundancies and unfair dismissals were going to shoot out through the roof. No, it's actually currently being touted for this year, that is going to really kind of hit the fan because of all the restrictions that were lifted by the government in respect of the wage subsidy, restrictions on layoff, and so on. They're all now gone. But if we look at mediation, so for those who are not aware, the WRC proposed mediation. They refer to them as interventions. And I don't quite understand that, but they made 2,120 interventions and only 582 of them progressed. So that's 1/4, just in around 1/4 of a success rate. 85% of them were done over the phone. Now, if none of you have ever had the pleasure of a mediation phone call, they pick up the phone and they generally ask, what's your number? And that's it. And if you say it's X, or if you say we don't have a number because we're the employer and we're not paying anything, they will say, well, that's no good to us, and they hang up. In fact, I got a mediation text message for the first time the other day where they're saying, are you interested in settling this case? It's not very good. That's all I can say. But 14% of cases are held face-to-face. And I will say the ones that are held face-to-face are very productive. And I've actually had a good success rate in them, settling 6 cases at a mediation last year face-to-face. They do work. So hearing statistics, this is an interesting kind of chart that shows the number of cases taken per month. So in the blue, you have 2020, and in red, you have 2019. And clearly you can see that in April, May, June, no cases were heard. Obvious reasons, it goes without saying. But what you clearly see is a clear dip in cases because cases couldn't be done face-to-face. They had to be done remotely. And there was no facility within the WRC to allow online hearings. There just wasn't. You had to consent to do it online, and no one was consenting because they were very much afraid of the process. Then in October of that year, they introduced this Civil Law and Criminal Law Miscellaneous Provisions Act, which said that the WRC could list remote hearings without consent. So that kind of really urged the increase of those cases. And then following the completion of 2020, we saw 1,899 cases being taken. Go back to what I originally stated at the start. In 2020, over 8,000 complaints were lodged. Only 1,600 complaints were heard. There's something incredibly flawed about that. And now that's down by, I think, a substantial number of around 46%. But that's no justification, because at this moment in time, we've never had as many adjudicators and mediators. But for some reason, the numbers are just not adding up. They are not getting through cases. And before this, the backlog was huge. It was taking, on average, 6 to 8 months for us to get a hearing date, and on average, 8 to 12 months to get a decision. It's an incredibly flawed institution, and that has only increased. The backlogs have only gotten greater following the Lewinsky issue, which I'll come to at the end of this. The Labour Court statistics. If you're thinking about appealing to the Labour Court, this is worthwhile looking at. You only have a 52% chance of getting your decision upheld. So that's the same decision that you got in the WRC. You only have a 52% chance of getting that same decision. 19% chance of your decision getting overturned entirely, or a 25% chance of getting your decision varied. So if I'm appealing purely on the basis that I want more money, you only have a 25% chance of getting more money. That's really it. And those the statistics are quite telling, because the WRC just don't like doing it. They tend to take the road of less stress. So let's move on to cases now, protected disclosures. I don't know if any of you have heard of the Brania Rostera case, but this was a case that we actually got to manage, and it eventually ended up in the Supreme Court. But in short, what this guy did, he was a meat operator. He used to score meat in a factory, and he left his employment in June 2015, and then suddenly returned in July the following month. However, in September of the same year, on the day of work, he walked off his line and said to his manager, I got him a pain. I can't work. I can't score meat because I have a pain. And his manager said, look, we'll deal with it. Just go back to your station. And he ended up walking off. He didn't go back to work. So 3 days later, he was dismissed for walking off the production line. And for those who are not familiar with the meat industry, that if you walk off the production line, you really cause a backlog and a disturbance to the production that day. And it could really impact the overall output of the organization. So that was the reason why he was dismissed. But he argued that he was dismissed for having raised a protected disclosure. And again, coming back to that distinguishment between interpersonal, personal issues, as distinct from a wrongdoing within an organization, because that's what a protected disclosure is meant to be, a wrongdoing. So he alleged he was dismissed for making that wrongdoing to begin with. So the WRC rejected his case. Then it was appealed to the Labour Court. And the Labour Court stated that he did not disclose any wrongdoing. They stated that he, in fact, expressed a grievance, which is interesting. They made that distinguish. Even though it's not provided for in the 2014 Act, they distinguished between the two, and they relied on a code of practice that we keep coming back to, which is that guideline that underpins actual legislation. And in that, in the code of practice, it said that an employer can distinguish between a protected disclosure and an interpersonal grievance, despite the fact that it's not law. And the actual legislation doesn't allow for that. So just bear that in mind. So the matter was then appealed to the High Court. However, the High Court rejected them and agreed with the Labour Court. They said that, yes, it was a grievance. There's a spectrum, and on that spectrum, one end you have grievances, and the other you have wrongdoings to the organisation, and his was a grievance. They then took a very brave decision, and this is an employee that earned $22,000 a year, had 2 senior counsels, had 2 barristers and an entire solicitors team, and arguably no money to fund this case, but they appealed it directly to the Supreme Court, which is a leapfrog appeal. Go straight from the High Court to the Supreme Court. And only 14 of them are done every year. And the Supreme Court stated, there is no reason why a complaint for an alleged failure to comply with statutory obligations could not be regarded as a protected disclosure. And the reason they came to that conclusion was because they looked at the legislation. And they said many complaints by employees which are entirely personal to them are nonetheless capable of being regarded as a protected disclosure in accordance with the way the Act is structured. And this includes one own's health and safety at work. So the Supreme Court stated that the code of practice was erroneous, it was incorrect, and that it did not reflect the 2014 Act, that there was no distinction under the legislation between a protected disclosure and a grievance, and noted that the Labour Court incorrectly treated the Code of Practice as amending the 2014 Act, and it's not for the Labour Court to interpret the intention of the Oireachtas. Now, the judge had a lot of sympathy because he said he knew in his heart and soul it's not a protected disclosure, it's not what was meant, but unfortunately that's not what it said in the tin, and that they had to comply with the law. And that's what's being fast-tracked in respect to that disclosures bill that's coming through at the moment. They're really trying to narrow that grievance and protected disclosure element so that they get it right, so they avoid situations like this. So the employee has now won. The case is now going back to the Labour Court for reassessment, and he is likely going to lose the case because he walked off the production line, and you can't do that in the workplace. And that was the reason why he was dismissed, not for making a protected disclosure. So the takeaway for employers, personal grievance may amount to a protected disclosure if it amounts to a breach of a statutory obligation or relates to health and safety, pending the introduction of the bill itself. So now we're going to look at reasonable accommodation. For those who are not aware about reasonable accommodation, if you suffer from a disability in the workplace and you are in any way inhibited, you have to be accommodated by your employer to a certain extent. And I refer to like the Nano-Nagle decision, which is the primary case in this area. And a really good example is given in that, where they refer to an orchestra and they refer to a flutist in the orchestra. And they say if a flutist breaks their leg, you implement a ramp, you get an elevator system put in, you look at the costings because the measures that can be taken are very identifiable. But what if the person who plays the flute damages their vocal cords and they cannot perform the duty that they were hired to do, and that the one aspect of their job is materially altered? In Nano-Nagle, they said to make measures would be disproportionate in that scenario because it would, in fact, change the role entirely. It would be a brand new role. So that is the main issue that we're still struggling with here in Ireland. And in UPS versus Kevin Roberts was another case that we were involved in. Here it was an individual whose main aspect of his job was to travel, to fly. 1/4 of his month was spent in airplanes. It was consistent so much of that, going to different organisations, different UPS centres and assessing them. And due to medical reasons, he was unable to fly. He just couldn't fly anymore. He was fit to work, but one aspect of his job, which is a key aspect of the role, was that he couldn't fly. And they said, right, if you can't fly, we're going to dismiss you. And they ultimately dismissed him on the grounds of incapacity. He appealed that decision internally, and the same decision was upheld. He then lodged a complaint under the Employment Equality Act saying that they failed to reasonably accommodate him and they discriminatorily dismissed him. The WRC found it in his favour. They said he was not discriminatorily dismissed, but yet they failed to reasonably accommodate him. And they awarded him $20,000, which equated to 3 months' salary. We weren't happy with that decision. We then appealed it to the Labour Court based on quantum, because in theory, if he wasn't reasonably accommodated, then any decision to dismiss him would have been discriminatory. It was a flawed decision. So it was confirmed, the Labour Court, when they looked at this, they looked at the medical report. They looked at the medical evidence and said, what did it say? It said he was fit. They said he couldn't do an aspect of his job. And they turned around to the employer and they said, what did you do to look at that? And they said, well, he couldn't fly. It was end of. And they were like, but that's not the point. You need to actively, under Section 16 of the Equality Act, to go out there and test the feasibility of whether that individual's job could be done without flying. Okay? It's not a case of it can't be done. Show us it can't be done. Right? And the reality is his job couldn't have been done without flying. But they couldn't prove it. They adduced no credible evidence that he could actually not do his job flying. And in the absence of that credible evidence, the Labour Court hammered them. It was one of the worst things I've ever seen. For about 2 hours in cross-examination, the head of the Labour Court laid into the senior manager. And as a result, the senior manager turned around and said, yeah, we didn't reasonably accommodate him. So the Labour Court ended up increasing the award from $20,000 to $75,000, which represented a year's basic pay. And they said, yes, he was not reasonably accommodated and he was discriminatorily dismissed. And that's very interesting because if I can't do a key aspect of my job, if I can't type, if I can't speak, if I can't do anything, then in theory I can't perform my role. But what the Labour Court said, before you even get to that stage, you need to be able to prove it. And if you can't prove it, then you're breaching legislation. So takeaways for employers, again, the decision places a high burden on the responsibility of the employers in respect to reasonable accommodation, and employers should ensure that an assessment is conducted as to whether the proposed measures for accommodation are feasible before making the decision. Now, I'm going to give you a different case here, which is O'Brien Fighting Foods, which is Brady's Ham. And this is a very interesting decision. Again, we had a scenario where we had an individual who's a general warehouse operative. His job day-to-day was lifting. In August 2019, he had a medical report because he was injured at work that said he can only lift certain weights and he had to do physiotherapy. So the company said, okay, you can lift certain weights, let's see what we can do to adapt that. And 2 months later or 3 months later, another medical report came in that said he could lift no weights. So it changed the position. Then he started looking for alternative work within the organization that was more kind of admin-based, so that he didn't have to lift anything. And he didn't get any roles, and he was really unhappy about that. Then they brought him into another meeting and said, look, we're going to have to dismiss you on the grounds of incapacity if you cannot be fit to do your job. So they said, we're going to send you to one final medical assessment. And in that medical assessment, we're going to send your job description to the occupational assessor, and they're going to break down what aspects of your job can be done without lifting. And if taking out lifting out of your job materially alters it and is disproportionate, we're going to terminate you. Midway through that process, he resigned. And what's really interesting is that the decision that came out from the WRC was that they effectively stated that the requirement to reasonably accommodate does not mean creating a new job. It also means that we do not have to provide you with a different role within the organisation, which is helpful. It's very helpful. Reasonable accommodation is confined to the position that you're in. Now, what they said is about when the big question that arose during the case was, when does the requirement to reasonably accommodate arise? At what stage during the injury? And what the adjudicator stated was that originally when it happened, we were in possession of information in August to say that, okay, he didn't have to lift certain weights, and there was an element where he was fit to work. But after that, he was entirely unfit. And because he was absolutely unfit to do the job, the adjudicator stated that there is no right to reasonably accommodate them. You can't reasonably accommodate someone who's entirely unfit. So that requirement does not arise. Now, to be honest, I don't think that's right. But it's very different, and it provides a kind of helpful insight as to when we actually have to reasonably accommodate. Because according to this, we only have to do it when someone is partially fit, and there's medical evidence recommending it. So going on to redundancies. I didn't state it in the statistics, but this was the largest set of cases that was taken in 2020. It jumped up by around, again, akin to age discrimination, around 600% in 2020. And it's set to go up way higher. And this case of Ray Walsh, which you might have seen in the news, which was actually a case that Alastair ran, was an individual who was invited to a Teams meeting, and he was told with no agenda, no notice, that his role was redundant, he was being terminated, and that's it. And he was informed by the managing director that despite your 16 years, there was no alternative within the organisation. We can't find you an alternative role. That's it. There's no discussion. End of. So he was offered his statutory entitlements, which is your statutory redundancy, your annual leave, and your notice pay. And he said that that was a derisory offer and sought an enhanced package. And they said, no, good luck to you. So he was offered no right of appeal to that decision. And he was then terminated in June of that year. And critically, all his clients still existed. They were just moved to the UK, to the UK-based operations. Now, again, you're probably aware of this, but for it to be a genuine redundancy, you need to show that the role no longer exists, that the duties that that individual carries out no longer exist, and that the manner in which the redundancy was affected was fair. And we developed that to be akin to disciplinaries. Have we brought them through a meeting? Have we discussed it with them? Have we proposed alternatives? Have we allowed them a right of appeal? And so on. And the decision in this is just really reflective of the current environment for these cases. The adjudicator, in our view, wrongly accepted that it was a genuine redundancy. They said because the operations were closing down, it was a redundancy, despite the fact that he exceeded his sales targets and all his existing clients still existed. The work that he would have been doing for those clients still existed, but that's not the case. What the adjudicator focused on was the logic behind it and the manner in which it was handled. And in regards to fairness, the respondent argued that the complainant's redundancy was unavoidable. They said the branch was closing down. What are we supposed to do? And actually, I have a great deal of sympathy with that, because what's the point of entering into a 2-week process when the result is still going to happen? It's predetermined, in effect. You can't avoid it. And they said there was no alternative to redundancy, and there was no useful outcome would have emerged from the consultation process. However, the adjudicator stated that they should have been able to test this scenario. And they said, who knows what might have emerged from this discussion with the complainant about an alternative to redundancy. And in that paragraph below, they talk about his experience. You know, he could have contributed. Did you look at what his skills could have been used elsewhere within the organisation? He had serious language skills. Could they have been adapted elsewhere? Did you look at putting him on short time, layoff, allow him to extend his notice so he could find a new job? They looked at all those things and they said, you've adduced no credible evidence to demonstrate that. And as a result, they hammered the employer again, and they awarded up to €120,000, which was a year's basic rate pay. And critically, the adjudicator officer found that it was disturbing that the managing director during her evidence said, if he had just asked, I would have given him more money at the time. Probation. You're probably, again, familiar with this case with O'Donovan and Oversea Technology. This case, and I'll just kind of skim through because I'm conscious of time, that this was a case where a CEO went in and at a critical time in the organisation went on holidays, came back, and he was greeted by the owner of the organisation, and they said, sorry, we're going to terminate you because you failed to pass your probation. And Mr. O'Donovan took umbrage with this and sought injunctive relief because he tried to restrain the dismissal and said, you say it's my performance, but you've never allowed me an opportunity to improve my performance. So at the High Court, he successfully secured an injunction, and the judge at the time said, if you're going to cite performance concerns, you need to allow people to address those, an opportunity to improve. This decision was then cross-appealed by both parties because both parties were unhappy with the decision. And Costello J of the Court of Appeal did not accept the argument by the employee in this instance. They said that there was a right to fair procedures in relation to assessment of the employee's performance during probation, but to do otherwise would negate the concept of probation. So what he's saying is that, no, you have no right to fair procedures during your probation. I can dismiss you for whatever reason I want during that period. And actually, it's very loose now. And according to this decision is that if you have a probation clause and there's a termination element in that probation clause, I can terminate you with no notice at all, akin to a no-fault termination. So if you're in probation, you really run the risk of being terminated without any recourse available to you. So he ended up losing that case. So in the absence of clear contractual terms to the contrary, the position in common law entitles an employer to dismiss an employee for any reason or no reason upon giving reasonable notice. The principles of natural justice, so this concept of fair procedures, only apply in issues of misconduct. So again, if I'm sacked for reasons alleging that I've misconducted myself as opposed to performance and capability issues, then I'm not entitled to fair procedures. So unfair dismissal, again, this was a very much reported on case from last year where an individual who was fired herself, so she constructively dismissed herself because she wasn't afforded remote working. And at the time, she cited COVID-19 as the main reason as to why she wanted to remote work. She said the workplace was not suitable. And eventually, she tried to address this with her employer, and her employer refused and said that there was adequate measures there with physical distancing and PPE gear. And the WRC stated that it was okay for her to dismiss herself, that the employer failed to provide a safe place of work, and that she was providing sensible suggestions to combat a solution or to combat an issue, which was COVID. And in that situation, she only got €3,000 because she found a job 6 weeks later and compensations based on financial loss. But that just shows you that as employers, we cannot simply refuse remote working. Regardless of what the bill says, it's problematic. If there's a sensible scenario presented, we need to facilitate it. We need to hear it. We can't avoid it. So Anthony Little, this is a series of cases that are all going through the WRC at the moment of people who refuse to wear masks going into shops. And people who said, I've got a disability, I don't have to wear a mask, I'm exempt, and not producing any medical evidence. And a similar situation arose here where an individual, Anthony Little, tried to walk into a shop, said, I'm not wearing a mask, I'm exempt. He was asked to produce a certificate to prove that exemption. He refused to do so. He then sued the shop to say, you should have let me in, you've discriminated against me on the basis of my disability. You can't do that. And then eventually lost the case because he was unable to provide any medical evidence to prove his case. And we've seen 3 or 4 of these through our offices alone with these kind of cases arising. Just ridiculous. So returning from employment following protective leave. This is dangerous, this case, because it's not dangerous, it's probably the right thing that happens, but it just shows you how careful we need to tread when dealing with people returning from maternity leave, because when we go out for a period of time, our role changes. But this is really putting a strict review on it, that it can't change. Okay, and this was a case where an individual who worked in HR went on maternity leave, came back and realised that her terms and conditions were the same, she still got the same pay, she still got the same job title, but her reporting structure was different. She reported to the managing director and was responsible solely for contracts and policies, and that was slightly adjusted and taken away from her. And the adjudicator agreed, and they said, yes, your structure was changed. Despite your contract remaining the exact same, that in essence would not have happened but for the fact you went to maternity. So she was awarded 6 months' pay in that instance, and a further €9,000 under the Maternity Protection Acts. And there's a very strong case. So even if your terms of employment are not materially affected, that it's notionally a leadership issue or a reporting issue, that still cannot be changed. Yvonne O'Rourke versus the Minister of Defence. This was a really unfortunate scenario where a person who went on 2 periods of maternity And at the time, for performance reasons, the maternity leave was equated to sick leave for men. So if you were absent for a period of time, they treated that as sick leave, and therefore your performance review was affected. So in this individual, when she went for a promotion, she had poor performances from 2010 and 2011 because she was on maternity. And as a result, she wasn't able to get certain training, which prevented her opportunity for promotion. They then later rectified this following a thorough investigation and grievance investigation, and they rectified it. However, by that stage, when she went to go get the training, she was suffering from a disability which prevented her from actually doing it. So she could never do the role that she could have done back in 2013 at the time. So this was recognised by the WRC, and they awarded her the full 2 years' pay in that instance, as well as a reoccurring payment of $4,495 per annum. And this is a really strong case, and I hope that this kind of stuff doesn't happen anymore. It's rare these days, it is, but this was such a negligible example of not being afforded promotion due to the fact that someone went on maternity. And again, this represents a trend by the WRC to really hammer the employers in this, and they should, because they're really trying to stamp these issues out in relation to discriminating people for going on maternity or returning from maternity in relation to their role. So my last case I'm going to touch on is Lewinsky. You've known this, you've probably heard about it, it was in the papers. This was the case that materially altered the way cases are going to be handled in the WRC going forward. So Lewinsky was a worker, he was fired, he then tried to contest that dismissal in the WRC. The WRC then issued a decision on it despite not having heard the case. They attended one day, they provided submissions, but it was later adjourned, and Lewinsky, the employee, never got to make his case. So then this was appealed to the Labour Court, which then was judicially reviewed to the High Court. And what they tried to do was argue that the Workplace Relations Act, the act that governs the WRC, was unconstitutional, that it cannot be allowed to do what it was doing. And he argued that the WRC was acting like a court, which we call administration of justice. They were administrating justice, so if they're acting like a court, they should be bound by the same rules as an ordinary court. And they looked at certain aspects that adjudication officers are not qualified. They don't have to have any legal training. There's no facility to administrate an oath, and I can tell you now, people were constantly lying. But then when going to give oath in the Labour Court, their whole evidence would change. And there was no express provision for cross-examination of witnesses, and hearings were not public. So the High Court upheld the constitutionality of the 2015 Act, but however, this was appealed, again, by leapfrog, straight to the Supreme Court. And the Supreme Court agreed that the Labour Court and the WRC were administrating justice, however, were doing so in a limited capacity. They were doing so not to the full extent like the District Court and the High Court and so on. However, they did say that certain aspects of the 2015 Act were unconstitutional, such as administration of oath and hearings not being in public. So this resulted in the implementation of the emergency legislation that came in July last year. No cases were heard between April and July as well last year because of the deficiencies arising out of Lewinsky. They said if you wanted evidence to be taken on oath, therefore you shouldn't have to have your case heard because you have to wait for the legislation to come in to rectify that. So now, as a result, all cases are now public. You can now walk in, you can now log online and attend whatever case you want. People are now named, save and except for sexual harassment cases, protected disclosure and disability. So that's myself, guys. If you have any questions, feel free to ask them. I'm also going to stay around for a few minutes afterwards, so if you don't feel comfortable, I can talk to you afterwards as well. But thanks very much for your time. I really do appreciate that. Open the floor to yourselves, I believe.
Thank you very much, Rob. And that was the breadth and depth of material covered there is hugely impressive. In normal circumstances, that should be a half day of continuing professional development. But we'll kick off with questions. So if anybody has any questions.
The question that the question I would have is in terms of the maternity leave position, and you mentioned earlier in your presentation that with all of the protective leave that a maternity worker could have, they could be absent from the workplace for up to a 3-year period. Yeah. So how is the employer protected in terms of restructuring does take place in an office environment, particularly in terms with technology that we're now embracing? Yep. So how do you, where is the line that you can be afforded to cross with an employee who is off on maternity leave? You are going maybe under a restructuring in the organisation. that might not necessarily change their terms and conditions when they return to work, but maybe the role that they play might not be materially changed, but will have altered. So how is the employer protected? And is it can you communicate with the employee when they are on that type of leave?
Yeah, so that's a really good question, actually. So in essence, if I get it right, you're saying just the manner of the work that they do is carried out differently, and how you manage that. So we're actually dealing with a case right now where an individual was on maternity, then back-to-back parental, so absent for nearly 3 years, and updates came into place, technology came into place, and we don't dispute that. I think an employer should be allowed to implement new technology, and I think the WRC and Labour Court have recognised that in decisions that, look, the reality is that technology is taking over. The manner in which you do work will change. That does not mean the manner in which your reporting work or your duties have not changed. They remain the same, just carried out differently. I think you draw the line really when it comes to responsibility within an organisation. That seems to be the key difference, that if the changes have diminished your responsibility, so it inhibits your progress within the organisation, well then yes. So for example, if you weren't afforded training at the time for the new technology and everyone else was afforded training, but when you come back, you're just landed in it and not given training, well then you could say that you've materially disrupted them and you haven't afforded them equality amongst everyone else, and that might prevent them from progressing further akin to everyone else. But in terms of communications at the time, this is another issue. Can you communicate with someone on maternity? I would think yes, if it affects the role. I think you should. But in this instance with technology, I don't think you should have to, because the role remains the same, but just ensure that training is conducted when they return, and you should be allowed to do that. Because again, in this instance with that example of back-to-back maternity and parental, her role changed by virtue of technology. You know, the way she carried out accounts was completely different. It was done by a machine now. But she had no problem with that. It was the leadership aspect. She was prevented because she was the manager, and now that manager position was diminished. She was now the manager to the manager, effectively. So I think that is the difference. I don't think employers will be penalised for those kind of structural changes. And again, I think in this instance, transparency is key. That's really it. And I think communicating with the employee should be allowed. Does that answer the question? Sorry. Mm-hmm. Very good. Mm-hmm. Anyone else?
Just in relation to the remote working and that whole self-assessment piece, because that obviously worries me. If somebody goes home, sits on the couch over the laptop, and next thing there's a back issue. You know, I presume if that goes to the court, the employer will be liable in some shape or form.
Yeah.
So therefore, you know, it seems to be a kind of a mad position to be in.
It is. I think as it's currently worded, it's very poor. I know how it's being done at the moment is you're seeing assessments through Microsoft Teams. I don't know if anyone's had the privilege of doing that, where they bring the laptop around, they try to adjust it, and you have an expert health and safety specialist reviewing that and saying, move your desk to light, move it to the corner. But I personally don't think it's sustainable. I think the employer should be allowed and should be actively trying to assess the area, because regardless of the fact that the remote working bill is silent on it, under the Health and Safety Acts, there's a duty on you. And it would be incumbent to say, well, if I can't fully assess that, I cannot let you do that for health and safety reasons. So if, for example, an employee is refusing to let you assess their remote working station, in theory, you can't let them work there because it's not safe. You cannot guarantee a safe place of work.
But I presume the logical thing is to codify that in your own policy or procedure as an employer.
Yes, yeah, exactly. So that's why it's quite key that if you have in your policy, you say that you reserve the right to carry out an assessment, and that assessment is ongoing. So if you're doing a remote working arrangement, that you have a provision there that you can regularly test their internet, that you can regularly test, their workstation if needs be, and do spot checks when required with reasonable notice. I think that is the only way you can manage it, and that's why those remote working agreements are so helpful. Because if an employee says, well, you can't do that, and say, well, actually I can, you signed up to it. And I think that has to be conditional on doing it. But just even with the internet activity element, and that's the biggest issue really I find, is that people's internet dropping off. Those agreements should have wording around that to reflect, well, if your internet drops off, you have to be on site. You have to come on site. And if there's regular disturbance, then the agreement is cancelled on that basis, But yeah, it's completely onerous at the moment under the remote working bill. It's not satisfactory. But to be fair, there's far more scope for the employer to refuse it based on that subjective subjective determination, which is, again, at their absolute discretion.
I had two quick questions, Robin, if you don't mind.
Anytime, Michael.
Specifically on protected disclosures.
Yep.
Does the complainant have to provide prima facie evidence of wrongdoing. And secondly, the other question, because I'm not aware of it myself, is there any obligation as of now to disclose the gender pay gap in the annual report?
So just to deal with the first question, do you have to present evidence that there's an actual wrongdoing? I think an initial determination can be made by the company to say, you haven't produced any evidence of an actual wrongdoing. I think that's safe to say. I think there must be something substantive with it. There must be, like any complaint, like a bullying and harassment complaint, you have to adduce actual examples. You cannot just notionally say there is a wrongdoing here and you need to do something about it. But really it's incumbent upon the employer when they receive that, and particularly where it's communicated at the time as a protected disclosure, to actively look into it and see, is there evidence? If you cannot establish evidence, then there's no protected disclosure to be made. But you need to be seen to be taking those steps, because under law, it's presumed to be a protected disclosure until otherwise proved. And you can only prove that by carrying out an investigation. So there's a presumption that it is a protected disclosure. So again, you go back to that scenario where someone said, I've got a pain. It's not a protected disclosure. But until we prove otherwise, we have to assume it is. And that's the point. Does that answer that aspect?
Yes,
Michael? And sorry, your second question was?
As of, is there any, or is there likely to be any requirement that the gender pay gap will be disclosed in a company's annual report?
Yes, well, like what's going to have to happen is that it's going to have to be published for employees to access and members of the public to access. So that's the great thing about it, is that it's going to have to complete absolute transparency for everyone. Again, the difficulty I have is that where you publish it is currently unclear. Again, companies are doing it online, so I can go onto PwC and I can see exactly what their gender pay gap is. I can see what steps they're taking to try and amend that gender pay gap. But it's going to create, and rightly so, it's going to create difficult conversations for many people, because once that first disclosure is made, and we know organisations now are trying to preempt this, and there's all of a sudden increasing wages for women, and because they don't want the optics of that first report to look very poorly, but they know they're trying to preempt that from ever happening. But but the first report is going to come out in June of this year, and that's going to then have a second report in December. And you're probably going to see major differences between June and December when people start realising how much less they're being paid than others.
Okay. I think we have time for maybe one or two other questions.
Yeah.
We might take a question from Ruth.
Thank you. Just in relation to the reasonable accommodation and the nano-nagal, and the obligation on the employer to produce evidence to say that they have looked at alternative employment. Is it sufficient, do you think, in relation to the employer saying that they have looked at it and they've examined it and for the employer to give evidence, or is it necessary now for external, for an occupational assessor to provide that evidence?
I think there's a case from 2014 that really sets it really well. It's called Westwood Fitness, for anyone who's a gym member in Dublin. It's kind of like a three-tier step. As an employer, we don't know, or we can't comprehend what is required for disability. So the first protocol is to get medical evidence. So that is your first step always. If someone is saying they're suffering from a disability but want to come back to work, we need to find out, can they work? And usually we'd ask the occupational assessor, and you really have to press them for this information because they won't give it otherwise. Tell us what aspects of the job they can do, what they can't do, and what measures you recommend from a medical point of view be taken. I refer to that Brady's Ham case, where the doctor actively recommended that he not lift weights over 3.5 kg and then try to work around that. I think that's the first step. The second step is that you need to sit down with the employee and go through this and try get their views. Because again, with nano-nagal, consultation is not a form of law, but it is strongly recommended as a prudent employer that you consult with the employee and get their viewpoints, and to be actively seen to be doing that. And it's critical that that meeting is recorded, again, that minutes are taken, and you formalise it far too much. But after that, then, it's up to the company to sit down, arguably at management level, or whoever is responsible for that, and say, look, here's the medical evidence, here's the employee's views, let's see what we can do now. And that is a case of saying, well, in this instance, in the weightlifting instance, he said, did you guys look at the costing of getting machines in that would supplement the lifting process? And the answer was no. That was an issue. And I kind of was thinking at the time, that is something that they probably should have looked into. And that's what I think is expected of employers to look at, to see what can we do? Okay, if it is getting a very expensive machine in, let's look at it. How expensive is it? Can we afford it? No. Well, at least we've tried to look into it. And I think that's what the kind of active demonstration that you need to be doing. And you need to demonstrate this to the employee then. So a further meeting then needs to be held so you communicate the outcome of it and you explain it to them. And if possible, you provide them a report of what efforts you've made. It's incredibly onerous. I mean, it's not straightforward. And I'd be very surprised if an employer can do it successfully the first time, because it's incredibly stressful and it can become very contentious very quickly. Does that answer the question? Sorry. Yeah, no worries.
Can I just ask a very quick question? And it was interesting, thank you, the distinction you're talking about between grievances and wrongdoing and the protected disclosure legislation. But with regards to data access requests and similarly genuine requests, but then requests which may be, nearly a little bit punitive and very extensive, and you're talking about how onerous some of the obligations are in employers. How have you seen the trends with regards to how the access requests are being utilised nearly in a punitive manner, and they're so extensive and onerous on employers? And where is that going in terms of, do you see any changes because it is relatively new?
This is kind of a personal favourite area of mine, but certainly in my experience, 75% to 80% of data access requests are used as a precursor to a case being taken. So whether that happens at the infancy of the matter where a disciplinary process is being taken, or it takes place after they've been dismissed. In terms of kind of arbitrary requests, there is scope under the Data Protection Acts, if you look at Article 12.5, to refuse a request entirely where it is overly complex or arbitrary in some way, shape or form. The problem is we have no guidance on that. And the risk that you have by refusing a data access request is that you've committed a data breach. And you need to be able to stand over that. And in this jurisdiction, that has not been tested fully yet. And you'd be flying blind. But you can narrow it. So in terms of how I deal with data access requests, when I get the request in, within 5 days, I'm writing to them and saying, because generally the request is, I want all my data. And they're just not entitled to it. Like, it's a huge misconception that they think they're entitled to minutes, emails, all these things, and they're not. They're entitled to the data that's extracted relating to them. If it relates to their role, if it concerns commercial data, it all has to be taken out. And actually, a good data access request is about 70 to 80% redacted. That's really it. But in terms of excessive documentation, I try to narrow the scope from the outset. So I'm saying, like, look, this is going to take time. We're not going to get this done in a month. We propose to respond in this way. So we'll give you 6 years of your statutory forms. We'll give you all your disciplinary record. We'll bog you down in working time records and so on, and try to flood them with that information because it's non-intensive information. But unfortunately, that employee can turn around and say, no, I want all my data. And the only way you can restrict it is then under Section 59 allows a number of restrictions to data access requests. If data was generated and contemplated of litigation or legal advice, I'll give you a really good example where an employer openly admitted to me that when they were looking for my opinion, that they dismissed someone because they had Crohn's disease. That's terrible. But thank God they wrote that to me and not someone else in the organization, because that is privileged. So when that person 2 weeks later did a data access request, I had to furnish that document, okay, because you still have to show the existence of the document, and you show them the date and that it's about them, but the body of the document is redacted because that's the privilege element. So again, emails is the most common one. You will see your email footer with your name at the bottom. So that's personal data. So every email you send is personal data, but the rest of it relates to the organization, and it's all redacted. So that's really it. But in terms of dealing with them, unfortunately, there's no fast tool at the moment. Unless you really want to be that first person that says, do you know what, this is complex, it's arbitrary, I'm not doing it. Now you could, if someone has made a number of requests successively within a short period of time, you could say, actually, no, we've given you this data, you have it, I'm not providing it there. An alternative then, if you look at section Article 12.6, and apologies if I'm going on too long about this, you can impose an administrative fee. Okay, so if you think that you're going to incur a cost because of the complex nature, you can charge a fee. So I'll give you an example of CCTV footage is a common one that we tend to use. And again, this is untested in this jurisdiction. We impose an administrative fee to say that we need to pixelate this and it's going to cost €2,000. And often they'll say no, or they report us to the DPC. And then you have to answer that to the DPC then. The problem is that this is one of these areas that there's so little guidance on. And data access requests, there's a huge misconception. So every time I give a data access request, it invariably gets reported to the DPC because they're like, that can't be right. But unfortunately it is, because you do redact most of the information that's on it. because you'd be surprised if I generate information as a solicitor, not information relating about Robin Hyde, then that's not personal data. It has to be related directly to the person. Does that make sense? No worries.
We have time for one more question. Okay, I think Esther's last question sent a shiver down my spine, because it just strikes me that a student could ask for every conceivable piece of documentation over the course of their 4 or 5 years of study, and that could be a difficult thing to accomplish in practice. Robin, that was an absolute tour de force, and you have an encyclopedic knowledge of the law, and I think that was conveyed very clearly today. Can I thank you very much for your presentation?
No, thanks everyone.
Can I say a specific word of thanks to Arlene, who does all of the management and the logistics behind the scenes. I often liken her to the great Oz, that she's the one who pulls all the levers, and it all looks very smooth. So we're very much appreciated for the work that Arlene does. And thank you very much for your attendance. We wish the numbers were a bit bigger. But hopefully we'll be able to grow from this. And I do think employment law is going to be the topic of this year, absolutely. So thankfully it replaces Brexit. So thank you very much, and hope you all have a very productive remainder to your day. Thank you. Bye.
Thanks so much, guys. Appreciate it. Thank you.